Good morning, and welcome to this public meeting of the United States Consumer Product Safety Commission. We have one item on our agenda this morning. CPSC staff will brief the Commission on the recommended final rule, amendments to firework regulations briefing package. The CPSC staff members who are here this morning to brief us are Dr. Rodney Valeri, who is a chemist, Dr. Andrew Statnick, Associated Executive Director for Lab Services, and Ms. Meredith Kelch, Office of General Counsel. Welcome to all of you and good morning. At the conclusion of this morning's briefing, we will turn to questions from the commissioners. Each commissioner will have 5 minutes for rounds of questions, and until such time as all questions have been answered and the commissioners have exhausted their questions. So with that, I will turn to the staff and ask them to proceed with their briefing. Thank you very much.
Good morning, Acting Chairman Burkle and Commissioners.
Excuse me, Dr. Valeri. I'm just going to check to see if are we broadcasting? I just want to make sure if anyone is. You may proceed. Thank you.
Good morning, Acting Chairman Burkle and Commissioners Biacco, Adler, and Kay. I'm Dr. Rodney Valier, along with Meredith Kelch and Andrew Statnick. Before I begin, I would like to acknowledge my team members, Meredith Kelch, Jason Young, Mark Bailey, Youngling 2, Priscilla Verdino, Matt Romer, and Jason Howe. Without their patience, dedication, perseverance, and hard work, this package would not be possible. I want to thank you all. Okay. Today, we will be presenting the amendments to fireworks regulations, recommended final rule. First, I will be discussing the background of the amendments to the fireworks regulations. Then I will hand the presentation over to Meredith for the statutory requirements. I will then discuss the NPR and the comments we received in response to the NPR. I will then go over the injury and death data. I'll brief you on the existing voluntary and international standards, followed by the staff's recommendations for the final rule. Further, we will explain the impact of aluminum on energetic materials and describe the economic analysis. This is a brief review of the fireworks rulemaking process to this point. In 2006, the Commission issued an ANPR to address the risk of injury associated with fireworks. In the period following that, staff conducted specific research focused on the composition and energetics of the break charge of fireworks devices intended to produce audible effects, which are addressed in the current regulation at 16 CFR 1500-17A3. The 2015 op plan called for the staff to complete a fireworks rule review, and this briefing package was submitted in December 2015. The Commission instructed the staff to prepare an NPR briefing package, and this was submitted in December 2016. The Commission published the NPR in February 2017, and the 2018 op plan directed staff to develop a fireworks final rule. I now will turn it over to Meredith, who will discuss the statutory requirements.
Okay, so there are two statutes that govern this rulemaking in large part, the Administrative Procedure Act and the Federal Hazardous Substances Act. The Administrative Procedure Act, or APA, which gets a little confusing when you hear later that there is an APA voluntary standard, but for now, that's what we mean by APA. Rulemakings in general are subject to the APA. It requires an agency to provide notice of a proposed requirement and the opportunity to comment on it. It also provides for judicial review of agency rulemakings, providing, among other things, that a court is to set aside a requirement that is arbitrary and capricious. In other words, a requirement that is not based on and tied to supporting data and facts. The FHSA provides CPSC's authority to regulate fireworks. It authorizes CPSC to classify a hazardous substance as a banned hazardous substance, which includes performance and design standards, and it provides additional requirements for rulemaking. The recommended final rule includes two types of requirements. The first are clarifications of regulations. These take the form of definitions, more precise terminology, and eliminating inconsistencies in the regulations. The second type are new requirements. These constitute new hazardous substance bans under the FHSA. The first category, clarifications, does not create new hazardous substance bans, so these need only comply with the general rulemaking requirements in the APA. The second category, the new requirements, must also meet the APA requirements, but also must meet the rulemaking requirements provided in the FHSA. The FHSA rulemaking requirements consist of essentially two groups. To adopt a hazardous substance ban or create a new performance or design requirement, the FHSA requires the Commission to make 4 findings and to prepare a final regulatory analysis. The next 4 slides discuss the required findings, and then I will briefly cover the final regulatory analysis. The first finding focuses on the degree and nature of the hazard presented and whether public health and safety can only be adequately protected by keeping the substance out of commerce. And I'll give everyone a moment in case they want to read the actual regulatory text. The second finding deals with the adequacy and effectiveness of existing voluntary standards that address the hazard that the regulation aims to address. When there is a voluntary standard that addresses the risk of injury that the regulation seeks to address, the Commission must find one of 2 alternatives to issue the regulation. First deals with the effectiveness of the voluntary standard at adequately reducing the risk of injury. The second deals with the likelihood and extent to which regulated entities will comply with the voluntary standard. There are 3 voluntary and international standards that deal with fireworks, which Rodney will discuss shortly, and are therefore relevant to this rulemaking. The third finding considers the relationship between the costs and benefits associated with the regulation. The Commission must consider whether the benefits of a regulation bear a reasonable relationship to its costs. Benefits may include reductions in the severity or likelihood of injuries, and costs may include increases to manufacturing costs or sales prices, as well as decreases in availability or usefulness. And the fourth finding looks at the relative burdens and effectiveness of alternatives to the regulation. Staff considered several alternatives to this rule detailed in the briefing package, and which Rodney and Andy will cover in this presentation, as well as the costs associated with them and how effectively they may reduce the hazard the recommended requirements aim to address. In addition to the substantive findings, the FHSA requires that a final rule include a final regulatory analysis, which discusses the costs and benefits of the regulation, both monetary and those that cannot be quantified, and the impacted parties, as well as alternatives to the regulation, their costs and benefits, and why the Commission did not choose them. And finally, a summary of significant issues commenters raised in response to the preliminary regulatory analysis and CPSC's response to those. I'll now turn it back over to Rodney.
Thank you, Meredith. As I mentioned previously, the NPR was published in February 2017. Many of the proposed requirements aligned with the industry standard AP 87-1. Along with AP 87-1, there are 3 relevant standards that I will cover later in the presentation. These proposed requirements included a replacement for the current audible effects test, which incorporated a metallic fuel limit of 0% with a 1% discretionary allowance for burst charges exceeding 2 grains, and pyrotechnic composition limits on various devices. In addition, the Commission proposed requirements regarding base attachment, clarifications, and additional definitions, codification of the side fuse ignition test, which appears in the CPSC Fireworks Testing Manual, as well as the addition of prohibited chemicals with trace contamination limits and prohibited projected fragments. Final rule staff recommends includes the first 4 bullet points proposed in the NPR, with 1 slight modification to the second item, and omits the last 3. CPSC received over 2,400 written comments on the NPR. CPSC subsequently held a public meeting for oral comments in March of 2018, which included 11 presenters and resulted in a couple hundred additional comments. Staff has met separately with several industry representatives from the APA, AFSL, NFA, and SBA with regards to technical issues raised in the comments from the NPR in public meeting. Some of the major technical issues raised by the commenters centered on the metallic fuel limit for burst charges exceeding 2 grains. These comments included a request to set the metallic fuel allowance at varying levels, ranging from 0 to 15%. Commenters also questioned the effectiveness of limiting metallic content on the risk reduction and suggested alternate test methods. This recommended rule aims to reduce the risk of injury for the device types that generally produce the greatest explosive power. One of the primary powerful device types that this rule would address are reloadable tube aerial shell devices. As you can see from the chart, reloadable tube aerial devices accounted for 12% of all estimated fireworks injury during the 2017 special study period. This makes reloadable tube aerial shells the second leading device type associated with injury. In prior years, sparklers have generally been the #1 cause of injuries, followed by firecrackers. In addition to reloadable tube aerial shell devices, the other type of device that produces the greatest explosive power is the mine shell device. So these two types of devices are the main devices this rule focuses on. To give everyone a visual representation of mine and shell devices and reloadable tube aerial shell devices, here is a picture of both. With a mine shell device, you light the fuse and a lift charge, and each tube projects a shell into the air in sequence where it explodes. In a reloadable tube aerial shell, a shell is loaded into the tube one at a time, and when lit, a lift charge in the shell projects it into the air where it explodes. The user then loads another shell into the tube and repeats. There were 23 fatalities associated with fireworks between 2015 and 2017. In this period, reloadable tube aerial shell devices are the #1 cause of fireworks-related fatalities. 16 deaths can be associated with these high-power devices. I would like to talk a little bit about the industry standards that staff considered while reviewing the fireworks regulation, with a goal of reducing the injuries and deaths due to consumer fireworks use. First, staff considered AP 87-1, which DOT incorporates by reference in its rule regulating transportation of fireworks. DOT offers 4 options to obtain mandatory DOT approval. 2 of these options require compliance with AP 87-1. In her comments at the public hearing, APA's representative said that approximately 99% of all firms use one of these 2 options. APA membership consists of nearly 85% of the fireworks industry. Because DOT incorporates the APA 87-1 standard, we primarily focused on this standard in developing this rule. AP 87-1 standard contains various provisions where staff has recommended harmonization. Secondly, there is the AFSL standard, which has a number of provisions in addition to the CPSC and DOT requirements. AFSL represents an estimated 85 to 90% of all U.S. fireworks importers. The requirements in the recommended final rule are largely consistent with the requirements in both AP 87-1 and the AFSL standard. Finally, the European standard is used by 31 countries around the world, and many devices do not correlate to what is found in the U.S. market. In fact, many of the devices in the U.S. would be prohibited in Europe. As I mentioned earlier, some of the requirements proposed in the NPR are not in the recommended final rule. The NPR requested additional information to support these proposals, but we did not receive the needed information. Without additional information, such as injuries, health and safety, or the level of compliance with voluntary standards, there is not sufficient support for FHSA findings and are therefore not included in the final rule we are recommending. As for the side fuse ignition proposal, there is already a high degree of compliance. The requirements that staff recommends for the draft final rule fall into two categories: clarifications and new requirements. The clarifications consist of definitions for terms used in regulations, revision of wording to make existing requirements clearer, and correction of a conflict in the regulations. These do not change the substance of any of the regulations. There are also three new requirements. The first deals with the existing requirement in 1500-17A3, which limits devices that are intended to produce audible effects to 2 grains of pyrotechnic composition. We currently determine whether a device is intended to produce an audible effect by firing it and listening to the sound it produces. Identifying this sound requires training and experience, and the sound a device produces can be impacted by various factors. Consistent with AP 87-1, the final rule retains the 2-grain limit, but replaces the audible effect method in the regulation with an objective, repeatable method that assesses the content of the burst charge. Recommended rule applies the 2-grain limit to devices with a burst charge containing fine mesh metallic fuel. For reasons I'll discuss later, the recommended rule also provides enforcement discretion to allow up to 1% fine mesh metal in a burst charge. Second new requirement staff recommends are limits to the pyrotechnic composition for aerial devices, including the overall device and components of it. While the NPR proposed these limits for both aerial and ground devices, the final rule only includes them for aerial devices. The third new requirement is that bases on devices that operate in an upright position must remain attached during storage, handling, and operation. Staff believes that based on testing and data, as well as information received during the comment period, staff had sufficient information to support these provisions. We will go into more detail in the coming slides. The first two new requirements address the explosive power devices produce. Increased explosive power presents an increased hazard to consumers with more severe injuries and risk of death. In later slides, I will address the relationship between fine mesh metal content and explosive power. Staff also recommends adding pyrotechnic composition limits for aerial devices. This is because larger amounts of pyrotechnic composition produce greater explosive power. I will also touch briefly on the relationship between explosive power and injury potential and severity. Although we cannot determine the precise relationship between a certain amount of explosive power and specific injuries, incident data demonstrates this relationship. We looked at the devices that produce the greatest amount of explosive power, mine shell devices, and reloadable tube aerial shells. As an earlier slide indicated, 70% of fireworks-related deaths in the last 3 years involved reloadable aerial shells. We also looked at in-depth investigation information for factors that indicate the severity of injuries, such as hospital admission, duration of recovery, surgery, long-term health impacts, and the injuries sustained. These indicated that these two device types were associated with the most severe injury cases. This demonstrates what common sense tells us, that greater explosive power produces more severe injuries. Currently, the only composition limits are the 2-grain limit on devices intended to produce an audible effect and a 50 milligram limit on firecrackers. For devices that are not intended to produce an audible effect and are not firecrackers, there are no such limits, and a device can contain any amount of pyrotechnic composition. Greater amounts of pyrotechnic composition produce greater explosive power. This recommendation, as with the limit on fine mesh metallic fuel in burst charges exceeding 2 grains, would limit the explosive force, thus limiting injury potential. This requirement would apply to the most highly explosive aerial devices, including mine shell devices, aerial shells with reloadable tubes, Roman candles, and rockets. The limits in the recommended rule are consistent with those in AP 87-1 that has been in effect for 30 years. Staff believes the combination of limiting the pyrotechnic composition as well as metallic fuel in burst charges exceeding 2 grains would adequately replace the current audible effects test. This and the limit on fine mesh metal content complement each other. This requirement would limit the content of devices that do not contain metallic fuel, while the next requirement I'll discuss focuses on metallic fuel, which produces greater amounts of explosive power, and therefore warrants lower limits than this requirement. Staff data and data provided in the comments indicate noncompliance with the industry standard on pyrotechnic composition limits, and the cost of bringing the noncompliant samples into compliance is estimated to be low. I would like to go into a bit more detail for each requirement in the recommended final rule, starting with the metallic fuel limit for burst charges exceeding 2 grains. As I'll explain in a later slide, as the amount of fine mesh metallic fuel increases in the burst charge, so does the explosive power of the device, creating a greater potential for injury. I would like to note that this requirement, without any contamination allowance, is in APA 87-1 and has been the industry standard that the fireworks industry has been self-certifying to for over 30 years. As compared to the current method, which is subject to variation, this method is quantifiable and yields consistent results. Technical staff believes that a contamination allowance is appropriate to account for instrument detection limits, instrument variation, and inadvertent contamination from the environment or other components of a fireworks device. Staff conducted testing to assess the appropriate level. Based on this testing, a contamination allowance of 1% allows for testing variation and contamination issues. Because higher levels allow for greater explosive power, we believe the contamination limits need to be kept to a minimum. A 1% allowance does that. Staff recommends this allowance be provided as an enforcement discretion rather than in regulation because, 1, this requires firms to strive to eliminate fine mesh metal content consistent with the safety purpose of the requirement. 2, it would better allow CPSC to adopt the limit as devices or contamination levels evolve. And 3, because it is possible to achieve zero fine mesh metal content, as a later slide will show. This graph shows the relationship of the addition of metallic fuel to explosive energy. This graph is based on the addition of aluminum, which is the most common fine mesh metal fuel in fireworks, to TNT, which is the standard for comparing explosive energy to different explosives. As I've mentioned previously, as fine mesh metallic fuel is added to the burst charge of a device, the explosive energy increases exponentially until it becomes too fuel-rich and it tapers off at higher amounts. As the graph shows, at low levels, each 1% addition of fine mesh aluminum increases the explosive energy by 3%. So adding 2% by adding 2% fine mesh aluminum, the explosive energy increases by 6%, 3% aluminum increases it by 9%, and etc. APA and AFSL's joint comment on the NPR included testing data on the fine mesh metal content of burst charges in a large number of mine shell devices and reloadable aerial shells. This showed that roughly 59% of mine and shell devices and reloadable tube aerial shell devices contain a less than detectable level of aluminum. These devices comply with APA 87-1 and the regulatory limit in the recommended rule. This percentage increases to 85% when you account for a contamination allowance of 1% as staff recommends. Staff assess the costs associated with this requirement and expects them to be low, amounting to a few cents per device for those devices that require modifications at all. Although staff cannot quantify benefits, benefits are likely to exceed the costs of this requirement if it results in avoidance of as few as 3 incidents. I would like to turn it over to Andy Stadnick as he will present some of the alternatives that were considered in regards to the appropriate percent metallic fuel.
Good morning, Acting Chairman Burkle and Commissioners. Staff considered various alternatives to the 1% discretionary contamination allowance, including no allowance, as in the current APA standard, setting a different allowance level, or including the allowance in the regulation rather than as an exercise of enforcement discretion. I'll review these briefly now. As presented in Section 4B of the briefing memo, staff concluded that a requirement of no metallic fuel, 0% with 1% as an enforcement discretion allowance would serve the public safety interest while adequately accounting for inadvertent contamination and aligns consistently with the current test method. As an alternative, the Commission could issue a rule that provides higher allowances of metallic fuel. Staff considered levels higher than 1% because higher levels would reduce the impact of the rule by rendering fewer devices as non-compliant. CPSC staff compiled a limited data set comparing the results of the current audible effect test method that we use in the field to the percent aluminum in the burst charge. This data is presented in the next slide, which is Figure 1 in the briefing memo. For this data, staff tested a limited number of devices by firing a device in the field to listen to the sound it produced and testing a device of the same kind from the same sample set in the lab for fine mesh metal burst charge, in the burst charge. Because of variation of devices due to their handmade nature, devices tested in the field may not be exactly identical to those tested in the lab. But this data provides some indication of the relationship between the current test method and the one in the recommended rule. The limited testing indicates shells containing less than 1% aluminum were never found to produce audible effects. Shells containing aluminum between 1 and 3.5% were found to produce audible effects in the field 50% of the time, and shells containing greater than 3.5% aluminum were found to consistently have an audible effect 100% of the time. I will now review several of these allowance options in more detail. As shown in this table, the allowance levels of 2% or 3 to 3.5% would increase the percentage of compliant devices by only very small amounts. About 1% more would comply with the 2% allowance, which was recommended or suggested by AFSL and APA, and about 2% more would comply with the 3 to 3.5% allowance. In exchange, these higher allowance levels would allow incrementally higher explosive power of about 6 to 12%. At the 2% allowance that was suggested by APA and AFSL, 10% of the devices tested by CPSC were found to produce an audible effect. Up to a 3.5% metallic fuel content, CPSC testing found about 15% of devices produced an audible effect. And as noted previously, above 3.5%, all the devices we tested consistently produced an audible effect. Some commenters had suggested considering metallic fuel levels above 3.5%, including a 5% and even higher allowances for metallic fuel content. The CPSC test data show that above 3.5%, all devices were found to produce an audible effect, and a higher limit would mean that some devices that are currently prohibited by the current test method would be permitted. Using metallic fuel limit above 3.5% would likely result in a potentially less safe regime than the current standard. While staff recommends the use of a discretionary allowance that would be presented in the preamble to the final rule, another alternative that the Commission could consider is to state a specific metallic fuel limit in the regulation. Some commenters advocated that the limit be stated in the rule. They stated that this would provide greater transparency, certainty, and predictability to the regulated entities. They were concerned in their comments that an enforcement discretion limit could be changed at any time without notice. In contrast, staff notes that to provide the greatest safety, the regulation should not allow any metallic fuel consistent with the industry's own standard, but include an allowance for measurement uncertainties, potential manufacturing contamination, and the evolution of fireworks devices. Industry and CPSC data demonstrate that it is impossible to comply with this approach. As we noted, about 85% of the current market data complies with 0% with a 1% allowance. As depicted earlier on slide 20, on the prior slide, staff also considered adopting only one of the two draft requirements that aim to address the hazard associated with explosive power. At 16 CFR 1500-7A3 with the audible effects metallic fuel content provision, or A14 with the composition limits. Staff determined that both of these requirements are necessary to address the hazards associated with the increased explosive power, as discussed by Rodney. Each of the draft requirements addresses a different contributor to the explosive power, i.e. the quantity versus the metallic fuel content. Another alternative the Commission could consider is to retain the current audible effect provision without any changes. This alternative would not respond to the Commission's original direction in 2015 to update the fireworks regulation in response to industry requests for a less costly, more quantifiable, and less uncertain method. For firms that certify compliance with APA 87-1 to obtain DOT approval, they would then need to continue to conduct both the audible effects test as well as metal content tests to certify compliance with APA 87-1. This option would also not align with changes that have occurred in the fireworks industry, including new types of devices and changes in the use of different types of pyrotechnic materials. This is a presentation of the alternatives the staff considered, and I will now turn the presentation back to Dr. Vallure, who will review a few other alternative considerations that the staff evaluated.
Sorry about that. Thank you, Andy. Some of the other alternatives considered were test methods that would replace the audible effects test without focusing on fine mesh metallic fuel in the burst charge. One of those test methods raised in the comments was sound level meter testing. No valid test method was provided by the commenters. Sound level meter testing is influenced by many factors, including environmental factors, number and types of instrumentation, device designs, test methods, and location that impacted the results. Staff conducted preliminary testing based off of the European standard, and the limited results showed a lack of reproducibility and repeatability. Additionally, staff believes that sound level meter testing may be more costly than a limit of fine mesh metallic fuel, as well as significantly more time consuming. Staff also conducted research regarding black powder equivalency and overpressure testing. The results indicate that these test methods are less effective at determining explosive power and are more costly and burdensome than the limit of fine mesh metallic fuel in burst charges exceeding 2 grains. Also, staff recommends requirements for base attachment. Incident data shows that many incidents, often resulting in serious injuries, result when devices that are intended to fire upward instead tip over or fire in an unintended direction. Requiring bases on upright devices to remain attached could decrease injuries associated with tip-overs and also discourages holding fireworks. Data indicates that there is non-compliance with this requirement in the voluntary standards, and the costs of bringing non-compliant samples into compliance are considered to be low. As Meredith mentioned previously, the definitions and clarifications that staff is recommending do not need the FHSA findings that the other recommendations need. The majority of the definitions that staff is recommending are intended to align with industry standards. In addition, staff recommends replacing the phrase designed to produce audible effects with firecrackers or explosive composition as appropriate to be consistent with the recommended changes and provide greater precision about the requirements. For additional clarification, staff recommends moving the exemption for firecrackers to the appropriate locations in the regulations. This also applies to aerial bombs. The NPR had proposed an effective date of 30 days. However, commenters provide information about market cycles and that more time would be needed to sell existing inventory, modify existing designs, to test to meet the requirements, and to obtain compliant inventory for the next major fireworks season. Staff considered these comments and agreed that a longer effective date would be appropriate and thus recommends a 1-year effective date consistent with the market cycle. As I mentioned, for each recommended requirement, oh. As I mentioned, for each recommended requirement, the benefits of the provisions staff recommends in the final rule bear a reasonable relationship to their costs. The costs associated with bringing non-compliant samples into compliance are expected to be low. In summary, the changes staff recommends are intended to 1. Clarify requirements, 2. Reduce consumer hazards associated with fireworks, as well as 3. Harmonize with the provisions in the voluntary standards, and 4. Update CPSC's regulations to reflect current device compositions and current technological capabilities and test methods. Once again, the costs associated with these recommended changes are expected to be low, and staff believes a 1-year effective date would help relieve the burden associated with these changes. Thank you for your time.
Thank you all very much. We will now begin our round of questioning. I would like to start first of all, I'll say this is an issue that has really garnered a lot of attention, and I've heard from many people, and I appreciate that kind of engagement. I want to sort of just make sure I'm understanding where we're starting from, what the genesis of this was, and probably I'll do a little talking, and then it'll give you an idea of what my questions are going to be based on. But essentially what we were trying to do is correct the ear test, find a solution to what we, essentially, I think that's where the agreement begins and ends, is the ear test is too subjective and needed to be fixed. So what we wanted to do was determine whether the brake charge of an aerial device should be subject to the 2-grain, 130 milligram limit of pyrotechnic composition. So we decided, staff recommends to us, we align our regulation with APA 87-1, which is a 2-grain limit unless the brake charge has 0 fine mesh metal. In addition to that, now, so a lot of the discussion, and I will get to some questions about the fine metallic content, because that's been a lot of the comments, a lot of the concerns is that what the percentage is that we can link to injuries. And so I will get back to that. But I also want to point out, because, and what staff is recommending is this 0 to 1% contamination. Because APA also imposes another number of other limits, which really don't have any counterpart within the CPSC regulations. And so I do have one issue, because I think overall, part of what APA does is it makes our standard more stringent. And so therein lies, for me, some concerns in how we justify making our standard, if we align it with APA, more stringent. And so I'll have some questions on that. And then beyond making it more stringent, is there definitive information that would say making it more stringent would address this number of injuries and or deaths? So that's kind of how I'm thinking about this, and I'd be happy to have any one of you weigh in on that to see if I've got that, the basic kind of where we're starting from, correct.
Yeah, I believe that is correct.
Okay. So let's talk a little bit about the fine mesh metals, because we've talked a lot about that, and I'm trying to get my arms around that issue. Is the use of fine mesh metals, is that something new in the industry, or is it a new phenomenon, or has it been around for a long time?
It's hard to say, like, when it was first introduced. It's relatively new to our knowledge, and I think one of the commenters during the oral summary or the oral hearing back in March mentioned that they first recognized it being an issue somewhere in the late 90s, early 2000s.
Okay. So we have seen an increase. I mean, does our data show an increase in the use of fine mesh metals?
Unfortunately, we don't really have the data to show that. So currently we listen for an audible effect and we weigh it out, but we have never done like the elemental analysis on it until, the last 5-6 years probably. Okay.
One of the things that I've heard, and through all of the comments and all of the contacts that have been made, it's lawful to have more than 130 milligrams of black powder in the brake charge of the aerial device, so long as it passes the ear test. Is that true? And can you talk a little bit about that? Because it seems to me if they're overloading it with the black powder, whether or not there's metallic content in there, does that increase the explosivity and the danger that's attached to that device?
Yes, currently, right now, the only limits we have are the 50 milligrams for firecrackers, and if it's intended to produce an audible effect, it's limited to 2 grains or 130 milligrams. And currently, there are no limits on how much black powder, if they're using black powder as a brake charge. Currently, we do not have any limits on that, and I think staff was hoping to address that with the pyrotechnic composition limits that we have proposed, recommended.
Very good. Thank you. My time has expired. Commissioner Adler.
First, let me thank you for an incredibly well-done presentation, extremely exhaustive. As I was reading through the package, every time I had a question, you answered it about 3 different times in 3 different ways. So I actually have very few questions, and some of the questions I'm going to ask have to do with materials that you've already raised, but I thought it was fair, just in the interest of a full dialogue today, to ask them. I guess my first question is, what does DOT do about the fact that there is contamination and yet the APA standard and DOT don't allow for contamination? Do they have an informal enforcement policy?
So DOT's regulations do not explicitly require compliance with the APA standard, but as Julie Heckman testified, they believe that nearly all firms use compliance with the APA standard to obtain their DOT approval. From my understanding, DOT does not have a formal compliance program that routinely tests devices for things like metal content or compliance with APA in other ways. Firms essentially self-certify that they comply with the APA standard when they submit their application for a DOT approval. And in some cases, my understanding is if there were incidents or some reason to investigate particular devices or a particular firm, DOT may look into that, but they don't have a regular testing regime like the CPSC staff do.
Well, that's very interesting. So they have a standard, but it's rarely applied, and usually only if there's an incident that triggers that. And I'm wondering if there is an incident, and you may not know this, if there is an incident that triggers a DOT examination, do they have an informal policy about whether they're going to bring charges or not against a firm?
I don't know the answer to that.
I don't either. Okay, thank you for that. By the way, just a point of trivia, I never knew what TNT stood for, and I think if I wrote it down, trinitrotoluene. I now have something I can answer in trivia contests, so thank you for sharing that. We've heard, at least I've heard, a lot of comment recently, and I got a phone call yesterday, raising the issue of moving the contamination level from 1% to 2%. That would satisfy some folks who are otherwise somewhat dissatisfied. Could you again explain what this increase in contamination level from 1% just to 2% would do, what the additional explosive power would be? I realize you mentioned it, but I'd just like to have it explained again.
Sure thing. So looking back at the chart that you mentioned with the addition of aluminum to TNT, if there's, once again, TNT is kind of the comparison when you're talking about explosives, so that's what when you compare energetic materials, you compare it to TNT. And upon the addition of aluminum, with 1% addition of aluminum, we'll see a 3% increase in energy, and if you double it to 2%, you double the amount of energy to 6%.
Okay, and that seems critical in terms of, even if we can't specifically quantify what the effect that would be on injuries, just intuitively, that seems that it would be somewhat more dangerous and produce more injuries. Now, this is sort of a question of policy/law, but I'm not sure I got a clear understanding of why staff is recommending that we put the 1% contamination enforcement discretion into the preamble rather than to the rule. And Ms. Kelch, if I can ask this question, and I think I know the answer, but I'd need some confirmation. If we put it in the preamble, when the rule is finally published in CFR, the preamble does not show up in CFR, is that correct?
Yes, that's correct.
Okay, so then could somebody please explain to me what the point of putting it in the preamble, and from my perspective, you put it in the preamble, it's still going to be part of the standard. We could, not with a straight face, enforce with a contamination level below 1%, in my view, practically speaking. So what would be the advantage of putting it in the preamble as opposed to putting it in the rule, since we're going to be bound by it?
Sure. I think there are a couple of reasons that staff's recommendation is to include it in the preamble rather than the regulation. The first of which is the safety justification for staff's recommendation for that requirement in the first place, which is the closer to zero, the lower the explosive power, and therefore the better for consumer safety. And putting a zero limit, so to speak, in the regulation would require firms to strive for that level, with the understanding that an enforcement allowance would accommodate unintentional contamination or different readings that our staff may get when doing compliance testing than the original manufacturer testing attained. The second reason is alignment with the APA standard. The APA standard has no allowance for contamination at all, and for consistency between the two and harmonization, including an enforcement discretionary allowance would be more consistent with the APA standard. It would also better allow CPSC to adapt over time. The 1% level, as you probably saw in the briefing package, is based on extensive testing that Bureau Veritas and CPSC staff performed to determine what levels of instrument variation there are and what levels of contamination there are from sources within a device or sources in the environment. And those things may change in time as devices change or instrumentation changes. And as you know, changing a regulation is a somewhat heavy lift, whereas a contamination allowance would be something that the Commission could sort of less formally announce a change to based on those changing factors.
My time is more than expired. Thank you very much.
I remember that, Commissioner Adler. Commissioner Kaye.
Thank you, Madam Chair. And thank you to the staff for the great work and the thorough work. It's obviously been going on for a long time, and we really appreciate all that you continue to do on the issue. And we also appreciate all of the outreach from the various stakeholders. That has been very valuable as well, and I'm sure that will continue, and we look forward to more of that. I wanted to ask Dr. Valliere, in terms of that outreach, and you mentioned this in one of the slides, that there had been a number of meetings, especially after the oral hearing, to look at some of the technical issues. Could you give us a little bit more detail, please, about how those went? What are the remaining items where you see some gaps between the various stakeholders? It doesn't have to be a lot of detail. And whether or not you feel, from a technical basis, those gaps can be overcome, and how we would maybe do that. Thank you.
Thank you, Chair. Thank you, Commissioner Kaye. We met several times, and most of the times the issues that were brought up were either these contamination allowances or various test methods. And we had industry representatives in, and we gave them a demonstration of an XRF, and we provided how we would test, how we prepped our samples, and showed them how it was done. We also showed them the ICP, OES, and we showed them how we would prep that as well. There was been discussion over sound level meter and sound level meter testing, and staff has brought its objections, which I've kind of went over in the presentation. Just that there was a lot of questions. It's a lot of, without a proper test method, it's very difficult to really find a reliable test method. When we did sound level meter testing, there was the environmental factors, like how many sound level meters to use, how far off the ground. There was just a lot of questions. I do believe that working with industry has been a great thing, and it's been nice, getting everybody's input. And I do think ultimately a right answer can be reached.
Thank you for that. And when you say the right answer, do you mean that those gaps can actually be closed, and everybody who's a scientist can look at the same set of data and the same test methods and results and say, we generally agree? There may be a different policy call to make, but in terms of the actual science, do you think that is possible to achieve that elimination of those gaps?
Yes, I really do. I believe the science will always speak for itself, and I think that scientists, there might be some heated discussions, but I think ultimately, the numbers will speak for themselves, and I think that, we can ultimately get there.
Great. Thank you very much. Thanks, Madam Chair. No further questions right now.
Thank you. Commissioner Baiocco.
Thank you, and thank you to everyone in here who contributed and for your good work to the staff. There's a lot of moving parts from my perspective in this package and in the recommendations, and so how I've organized them in my mind, I would like to address them from that perspective so I make sure I keep them all straight. If I understand correctly, and please feel free to correct me if I'm wrong, the one issue, first issue in my mind anyway, is that we want to replace, want to change the wording of the statute and get rid of the devices intended to produce an audible effect, correct?
Yes, that's
Okay,
correct.
and that's the ear test, and we want to get rid of this because we're trying to measure whether a particular firework has 2 grains of pyrotechnical material, correct?
That's based on the intended to produce audible effects.
Okay.
So if it has an audible effect, then yes, it's subject to the 2-grain limit.
Okay, and so that audible effect, listening, is pretty subjective, and I think everyone agrees that the ear test isn't the most scientifically sound, right?
It's not the most scientifically sound, but it's not completely subjective. There is science to it. There is an educated guess. So I guess I never really explained in the presentation how we do it, but we actually go, when we go out in the field and we set a fireworks device off, we do listen.
And you listen.
Yep.
Okay.
But there is a sound associated with it, and it's involved, and I think this was probably, 30 years ago or 40 years ago when we didn't have the instrumentation. This was a fine screening method. So you would go and you're listening for, it says listen for a loud report, but it's not just loud. There is a certain type of sound where it's a sharp crack as opposed to a big boom. If anybody's ever knows the difference between shooting a rifle and a shotgun, there is a sound, and that sound, that crack that you hear is associated with the pressure pulse that you get from flash powder, as opposed to the more, if you look at the pressure pulse, it's a sharp peak, whereas for a black powder device, it's more of a broader peak that's associated with the explosion. Thank you.
Okay. And so those peaks and curves, they're not measured by any device. They're measured by your own ear, right?
Currently, yes.
Okay. I don't mean to be smart here, but did anybody take like an ear testing course in engineering school or chemical school or whatever your backgrounds are? Because I find that we're judging a product based on a subjective viewpoint of how we hear. And as you mentioned, you used the example of a rifle. I don't know anything about a rifle and how that differs from a different type of explosion. So I am concerned that the ear test is just not the best way to go. And I think what I'm hearing, and just to lay the foundation, is we all want to get away from the ear test. We're looking for something else, correct?
That's absolutely correct.
Okay. And so what the staff has proposed in the package, if I understand correctly, is that we need to come up with something else to measure whether or not there is a 2-grain limit on pyrotechnical material, and we're proposing to use like a sieve to put through the black powder and or black powder mixture that contains the fine mesh metal, right? And then that sieve or that screen will sift out heavier metals, a larger 100 particle size. Is that right?
The test that would be used is, the sieve is basically to sift out the small particles, the fine mesh particles, and in that material that drops through the sieve, it'll be a combination of aluminum, metal, whatever is used in the burst charge device.
Okay, and that's, we're going to get to that. It's,
Right.
we're going to determine, I think a lot of the discussion today is about what it is we're going to measure and what it is that we're going to find is compliant. But before we can get to what we're measuring and how to measure it, I just want to make sure that I understand. One of the recommendations is to get rid of the ear test, to use this sieve, if you will. It's more quantifiable. And then once we get to that, and assuming that that's what we vote to do, then the next step would be to understand what we want to have in the composition to make the firework compliant with the statute, correct?
That's pretty much correct. In the
Okay.
current, just to follow up, in the current test method, when we test the device in the field, if we determine that it has that sharp crack sound of an intent to produce an audible effect, back in the lab, we take another subsample and we open up and sieve that material to measure its weight. We don't check for the metal fuel content, we just check for the weight of that fine mesh.
Okay, and the ear test certainly doesn't tell us whether there's fine metal mesh or the amount of it, correct?
That is correct.
Okay, that's all I have on that one. Thank you.
Thank you. I'd like to go back to my discussion about the black powder. So if the break charge contains only black powder, no fine mesh metal, how much could be contained in that device that would still, I mean, do we know this? Let me ask you this. I'll start by saying, do we have data that would tell us how many milligrams of black powder could be in a device and still pass the ear test, produce no audible effect, and not have any metallic content? Do we know that number? Have we studied how much black powder could possibly be contained?
Unfortunately, no. Like these sizes of these devices, it's kind of across the board, so we don't really have any information on that. I'm sorry.
Okay. Over time, have we seen, and did you have an answer?
I just want to follow up with Ryan. Is that if under the device regulations for transportation, the current shells are limited to certain amounts of weights of pyrotechnic material within them and certain amounts of burst charge. So if we haven't seen, and I go back a little longer than Rodney in terms of fireworks field testing, generally the devices we've found that produce an audible effect have contained metallic fuel in them from what we've seen in the past. And there was just, you look at it, you see it's a silvery color substance. AFSL in its testing would drop the material. If they thought it produced an audible effect, they'd drop it in water because the aluminum fine mesh metal would float. It's one where we haven't, because in the prior test method, we just listened and then measured the weight. We didn't record data. We didn't measure the metallic fuel content until we started the rule review process in 2015, where we started to analyze that more carefully to align with the industry standard.
So just to clarify, it's not possible to produce an audible effect with just black powder. You're saying that everything you've looked at has the metallic content in it.
Yes, and you could, depending on the device design, in terms of thickness of the cardboard, amount of material, and other factors, you could potentially, there are times and situations and geometries that one could test. But we generally haven't seen it. When it's used just pure black powder, it's more of the loud bang, not the sharp crack sound.
Okay. I want to keep moving here because the clock keeps ticking, and get to, I think, Dr. Villari, was what you were mentioning, and one of the ways you mentioned to address the issue of black powder was in the ratio, in the break charge ratio, that's where we do deviate from APA 87-1. So staff excludes the lift charge from the denominator, whereas APA does include the lift charge, if you're following. I mean, is that, you understand my question? In that ratio, because I think that's where if I'm understanding it correctly, and we deviate from APA 87, and we do exclude the lift charge, that makes it more stringent. So I guess one of my questions is, why did we choose to depart from APA 87 on that point? Do we know something that they're going to change the standard, or was there a reason or a rationale to do that?
It's not necessarily different than the denominator in the APA. So the APA denominator is unclear in the standard and could be interpreted one of two ways. The recommended rule aligns with just one of those two interpretations. So I actually have the section here that we're talking about for APA 87-1, section 3.125 for mine and shell devices states that the burst charge in a component may not exceed 25% of the total chemical composition in the component. It further states that a component is the portion of a device that is propelled into the air and subsequently bursts open. The portion of a mine and shell device that goes into the air and bursts open contains only a burst charge and effects, but not a lift charge. Therefore, according to APA's description of a component and the makeup of these devices, the total composition in a component of a mine and shell device could be interpreted as containing the burst charge and effects, but not the lift charge. This would mean that the denominator in the ratio includes only the burst charge and effects, like we recommended.
Thank you for that answer, and I agree with you. There's ambiguous and there's ambiguity in the memo. Is there a way that we can get certainty and some authoritative response from APA so it's clear whether or not the lift charge is included in that denominator? You can get back to me, and you don't have to answer that right now.
Okay, could I get back with you on that, please?
Certainly. Commissioner Adler?
Thank you. I'm going to digress for just a second. If you went over to the FDA, they have a group of professionals who are the fish sniffers, because they haven't yet figured out a way using objective metrics that are purely scientific to measure rotting fish. And so they train people to be able to smell contamination, and that the FDA's approach has been upheld for years. I would say the same thing with respect to our ear test. I'm not saying we shouldn't try to move away from it, but I do want to go on record as saying it is not a subjective test. It is a judgment call test that is then followed by a purely objective test, as Dr. Stadnick was saying. And so it may not be the most direct way for measuring risk, but it is one that's, I think, a pretty good test, and it's one that the courts have upheld. So just a word of defense about the good old ear test. I did want to ask you a question about a comment that we got. Again, we got flooded with emails, and here's one in particular that is from somebody in the NFA. Last week, we delivered to the Commission a test report with empirical data proving that the proposed powder metals ban lacks a rational basis because it would permit more energetic burst charges than those it bans. The results show that the energy output of the hybrid powder exceeds that of the metals powder. It would appear that the proposed rule does not do what it's intended to do. Do you have I know you commented on that, but could you give me a quick 30-second response to that criticism?
I only got a brief look at that data set. All I can say is it's very limited. It could be a valid test, but I have a lot of questions due to the limited data that was there. There was only, I think it was 12.5%.
Yes.
But there was nothing, there was no zero, there was no pure black powder, so there was a lot of, it could be a valid test, but there's stuff missing.
Yeah, and this is one of the things that does concern me, just generically speaking and generally speaking, is that just on the penultimate moment when we're about to do a standard, people weigh in with, oh, we've got conflicting test results, and sometimes it's useful, sometimes it's not, but I would like the timing to be more evenly spaced. Dr. Stadnick, you look like you wanted to make a comment.
Yes, Commissioner Adler. On the NFA report we received, the type of testing and the method they did that in, one of the issues, it's very similar to the black powder equivalency testing that we worked on with AFSL over the years, starting in about 2005, 2006, when they first, sort of asked, hey, let's get rid of this ear test. And whether you take a small container and test it with different orifices till it explodes, or whether you launch a steel ball up and see if it hits the bell, so to speak, they're very similar types of tests. And we found, and it's presented in our briefing package, that black powder equivalency test was very indeterminate that AFSL was pushing at the time, and they've since kind of dropped that approach because it's very costly, very expensive. This type of test that they were talking about, they didn't evaluate. As far as the data we've seen, it's very limited in what they evaluated, and didn't look at pure black powder as far as we could tell. It's an interesting method, but it's also one that can be also very dangerous to run.
One of the reasons that I was so supportive of reevaluating the fireworks standard, which it seems to me has been a good standard for many, many years, was that replacing the ear test with the APA approach brought unanimous support among the industry members, and then at the last minute we find out no, au contraire, there isn't unanimity among the industry groups. And I just want to follow up on a point that Commissioner Kaye was raising. Just how wide is the discrepancy among the approaches with APA, FSL, NFA, and our staff? In other words, is there any likelihood that the parties could sit down and have further discussions and see if there isn't some consensus that everybody could reach that would be satisfactory to all, or have we exhausted all attempts to do that to prove successful?
I think we've had many discussions on this level and test methods, and I think everybody seems to be an advocate for their own test method and their number, and I still remain hopeful, though, and I hope discussions can continue that there is, some sort of number that's reached.
Thank you for that. My time's expired.
Thank you. Commissioner Kay?
No questions at the time. Thank you.
Thank you. Commissioner Biacco?
Thank you. So I'm going to put aside the test method. I'm not as effective as my colleagues here in jumping around. I have to try to keep this straight. So test method aside, let's get to what we're testing for, and that is this percentage of fine mesh metal. Okay, those are where my questions are coming from. And if I'm looking at your chart that you put up earlier, oh, I thought I just had it. The one with the graphs, are we able to put that one back up? The audible effect versus percent of fine mesh metal. Yeah, that one. Thank you. So what staff is recommending is that when we do our whatever test method we have, we're looking for no fine mesh metal, or you're recommending in various ways, we could allow for basically a margin of error or for contamination up to 1% of that mixture to have fine mesh metals, correct?
That's correct.
Just let me take a step back. When we say break charge and burst charge, are we using those the same? They're the same.
Those terms are
Okay.
interchangeable.
So lift charge, in my mind, is you light the fuse, that power shoots it up into the air. We're not talking about that as far as the mixture. We're talking about the part that's in the middle of the firecracker, that when it gets in the air, it explodes. That's the burst charge, right?
That is correct.
Okay. So if I understand this graph, somewhere between 1 and 3.5%, at least based on the ear test, we had 50-50 compliance.
That is correct observation.
Okay.
Yes.
Why then do you suggest that it should be less than that? Because there seems to be a little bit of room here in my mind. I'm not following why that is the staff's recommendation, that it be 0 to 1%. Actually, it's 0, but there is some enforcement discretion, correct?
Correct, 0 with some enforcement discretion. At levels of the samples we tested, at below 1%, there were no audible effects detected. So the observation is that aligning for consistency with the existing test method and having 100% consistency with the test method, we looked at the devices that were tested. All devices with 1% or less did not produce an audible effect, and therefore would not be subject to the 2-grain limit under the current test method.
And that's based on the ear test that we all agreed in my last round is not the most quantitative.
Right.
Okay, let's go to the next slide, or I'm sorry, the slide before that. So these are the samples that you tested, is that correct? So your 0 to 1%, you had 162 samples, right?
This is data from the industry, from APA and AFSL testing that was done by Bureau Veritas.
Okay. And I just see a discrepancy here. I'm trying to get an understanding. So there were 0 to 1%, we did 162 test samples, and then for the 1 to 2% and 2 to 3%, there was 8 and 6 as a sample.
The way there were a total of 616 samples overall, and of those, 85% that they evaluated and tested had less than 1% metallic fuel. In that range of 1 to 2 to 3%, there was a very small number.
Okay.
Typically, 14, 15. Those are the devices that they, commercial devices that are being produced that they randomly selected and evaluated for metal content.
So basically, what this chart is telling me then is, in addition to the 85% below 1%, there were a few additional percentage points of those products already in the market that comply.
That is correct.
Okay.
That's what we tried to explain in the table on the following table, a couple slides down, where we noted that. If you want to put that slide back up. Next one. So at the 1% limit, we have the current data from the industry shows 85% of the samples already meet that 0 to 1%. That based on the AFSL data that the Bureau Veritas provided. As you increase to 2% or 3.5%, there's only about a 1 or 2% increase in compliance of product on the market today, which, on the one hand, you look at it wouldn't take, there wouldn't be a huge burden to correct that and increase the compliance below. The other option is you could say, well, let's capture a little bit more of existing product on the marketplace.
And it also shows that there's a higher percentage that are complying with the standard as it currently is if you add those percentage points in.
That is correct.
Okay. All right. I'm going to stop with that little square.
Thank you very much. I want to just go back to Commissioner Adler's comment about the testing results we got from NFA. And this particular document did come in very recently, but this is not inconsistent. Other than the testing results itself and the testing data they provided is not inconsistent with what we heard at the public hearing as well as in their written comments. I'd like to, to me, it's very important to understand how staff is here, others are along, this is my imaginary percentage of metallic content. Staff is here, others have come along, 2%, 3.5%, and then you've got a NFA over here at 12.5%. So in order for us to find whatever that sweet spot is on that continuum of metallic content, percentage of metallic content, it seems to me maybe we should take some time to look at this data. And I'd like to hear from either one of you if that's possible, how much time it would take, and do you believe that it could be informative for the Commission?
I do believe it could be informative. If I had more time to review the whole thing, I just saw it, I think, Monday night, and I haven't really had enough time to review it, but I think staff, if we had a couple weeks to review it, I think we could get back, and it potentially could be really informative.
Thank you. I appreciate that, and I appreciate your willingness to commit to a time frame. And further up the food chain, I don't know if others start waving again. Thank you, Mo. But I appreciate that very much. I think it's well worth the time spent to see if we can't be informed more about this. I do want to talk a little bit about incident data, because that's very important to me, making sure we address the hazard and reduce the number of injuries and deaths when it comes to firework use. When it comes to injuries or fatalities with regards to these aerial devices, what percentage are caused by commercial or display fireworks that actually have gotten into the hands of the consumer? Do we have any data on whether or not there's some diversion from these commercial display fireworks that should not be anywhere near consumers' hands? Do we have any idea of what percentage of injuries are caused by a group of fireworks that may have been diverted to consumers inappropriately?
We have some idea. I can't really speak on percentages, but I spoke on 2015 through 2017, the deaths. So in 2015, 9 of these 11 deaths, there were 11 deaths in 2015. 9 of them were reloadable tube aerial shells, like I've explained, but 2 of them were homemade devices. So if you want to put them in the display category or stuff beyond our jurisdiction. In 2016, there were 4 deaths. 3 of them relating to reloadable tube aerial shells, and 1 of them was another homemade device. In 2017, there were 8 deaths, 4 of them connected to reloadable tube aerial shells, 1 possibly a reloadable tube aerial shell, a homemade device, a firecracker, which I am assuming is an illegal firecracker of some sort, and then a sparkler, but to be noted that sparkler was actually a homemade device as well. It was somebody making a sparkler bomb.
Thank you for that. In the chart, you talked about the, and you were very clear as to sparklers, and then I believe you said cherry bombs, and then the multi-loadable tubes, and then the mining devices. And that number seemed to be significantly less than, but it's included with the reloadable, as we saw in the diagram, the picture. Is that correct?
Yes, that's correct.
Okay, okay.
Acting Chairman, I'm sorry, if I could just add slightly to Rodney's previous response. If you take a look at portions of the annual fireworks report, there is a breakdown of NICE data that tells you how many what percentage of the incidents involved display devices and homemade devices, and those numbers are quite small. So there is some tracking through the NICE data of those types of devices.
Thank you. When we do our special study, I'm going to talk really fast because my time's expiring. When we do our special study for that time period around July 4th, and we are making phone calls and trying to get more detailed data, do we ask that question? Are we able to, from those calls and all the work that's done during that month, be able to determine whether it was a homemade device, whether it was a commercial device that got into a consumer's hands, or it just was a plain old consumer firework?
I'm Yongling Tu from ACTI. And when we conduct special study, we ask the consumer what devices injured them, and some of them report as public display. And then for the complete IDIs, most of the time they provide the type of the device. But for some of the victims, they were injured by fireworks used by other people. They don't know what the device.
Okay, thank you very much. My time has expired. Commissioner Adler?
I really don't have any further questions. I did, other than one, and that relates to sparklers. I seem to remember at some point when I was about to go and give comments to the press about sparklers, I was told that they burn at this incredibly hot temperature. And somebody was comparing it to an acetylene torch. Is my memory correct on that point? What temperature do these things burn at?
Yeah, an acetylene torch, and they burn out approximately 1,800 degrees Fahrenheit.
And I know they represent a fair number of injuries, not necessarily the greatest number, but a lot. But we don't seem to have many severe injuries associated with sparklers. Am I correct in stating that?
Yes, that's correct. That's
okay. So
mostly
there's
burns,
no,
lacerations.
yeah. At this point, there's no feeling among staff that we would need to do something with respect to sparklers.
Not at this point, no.
Thank you. No further questions.
Thank you. Commissioner Kaye?
Thanks, Madam Chair. I don't have any more questions, but I would support, to the extent that that's where the commission ends up going, some type of pause to allow staff to have the time to look at the additional data and see if that would be fruitful. Thank you.
Thank you very much. Commissioner Biocco?
Thank you. On the data that you were talking about, Dr. Vallier, the chairman took you through the numbers of deaths, and you then pared them back a little bit because some of them had to do with homemade devices, so that these regulations wouldn't help there. It had to do with sparklers and whatnot. So, of the deaths that were caused by these aerial devices that the regulations are designed to address, how many deaths would be mitigated or avoided based on the staff's current recommendation regarding fine mesh metal?
That's it's a very good question, but it's a difficult question to answer because I'm not sure how much energy in proximity of asking. We had a physiologist that worked on our team, and we talked to him, and he said when we asked about explosions, what's a safe explosion in proximity to the human body, and he said none. So it's really hard to say, how that would have affected deaths. I would like to think that less energy coming off, it could could potentially be less catastrophic. So I guess that's the best way I can answer it.
So you'd like to think that, but we don't have the data on the deaths. How about the same question with regard to injuries? How many injuries, burns, blow my hand off, blow my finger off, how many of those injuries by these aerial devices would be reduced, mitigated, or avoided based on limiting the fine metal mesh in the burst charge? That's the same answer?
Yep.
Okay. And with regard to the NICE data that was used to do the analysis here, we assume that NICE data is based on a nurse taking down the correct information while somebody's bleeding or has an injury, correct?
I believe so, yes.
Okay. And do you know how many people that, when we followed up and did the IDIs, what your sample size is?
Telephone IDI, we screen the nice incidents, pick up the ones with severe injuries, hospitalizations.
Okay.
And the injury involve the eyes, and then those are all the ones, the fireworks type, as Agent mentioned, the incident scenario is not clear. I pick those incidents and then assign them through the data system to the telephone IDI.
How many
But
of
this
those?
is
How many of those people did you speak with? That's what I'm trying to get an idea of.
it varies each year. It's not like not a known probability sample.
Okay.
It's just like
So
select.
what I'm trying to ask you is how many people did you follow up with and actually speak to? So when you interviewed them to find out what device they used or what happened, whether they were illegal or homemade, how many of those people did you speak to?
Each year depends on the response. The thing, because usually it's kind of in the past few years I assign around like 120 cases each year, but the completed ones vary from like 29 to 31.
Okay.
So
And some of those involved not aerial devices, homemade devices, correct?
yes.
Okay, and some of those 20 to 30 people that you spoke to also may have involved illegal devices that perhaps the person you spoke to didn't really want to admit to. Would that be fair?
Yes.
Okay. Thank you. I'm sorry, I didn't mean to bring you out of the audience again. I was just trying to get that nailed down. So, Commissioner Kay and Chairman Burkle, I could be interested as well in getting some more data, because at this point it strikes me as a lot of the recommendations that were made are based on a very small data point, and I think I counted 26 times that the staff used either cannot qualify or quantify, unqualifiable or unquantifiable, and so forth. So I was very nervous, if you will, about the data basis for some of the recommendations. I can tell you that I can get behind the new test. I can get behind some recommendation on the amount of mesh metal. I have at least based on the information you've given me, I have a particular area right now, but I'd like to have more data. And I don't know if we're going to go here, but just moving forward, I also think that the recommendation that the staff gave us that would require bases on upright devices to remain attached is a no-brainer, and I could get behind that.
Thank you very much. I have a question about exposure, and I'll take a pause here because Commissioner Adler also indicated he's interested in taking a pause and having staff take a look at the most
I'm sorry,
recent.
did I miss that? I'm sorry.
No, he whispered it to me, so I just want to say we're all in agreement on that issue, and I think that's a good thing. So we'll intend on talking to staff about making that happen, and I appreciate staff's willingness and your openness to take that data on at this late time and to consider that and get back to the commission. I have a few other questions. I do want to just, because this is something that always concerns me when we're talking about injury and deaths, and that's exposure. Do we have any sense or any information about I know, like, I'll say, for instance, in my state, New York, you now can go into many retail outlets and retail stores, and you can buy fireworks. You could never do that. You'd have to stop off in Pennsylvania before you got to New York. But so the availability of fireworks, consumer fireworks, is greatly, I think, enhanced. Now, this really isn't your bailiwick. Exposure is more in EPI and trying to understand. But I think that would also be something important for us to know, not particularly for this rule, but just going forward. I guess it is to inform the rulemaking as well, because essentially if maybe the numbers have remained constant, but maybe the rate has gone down. We don't know that. We only know actual numbers of deaths and injuries per year. And knowing that exposure, knowing how many more consumer fireworks are or aren't out there, I think could be very useful in how we proceed as a commission. So maybe I can talk my colleagues into an exposure study at some point, but they've been dragging their feet on that one. Anyway, I have other questions. I'll submit them in writing, and then we will, of course, publish those on the website. Commissioner Adler, do you have any other questions? Commissioner Kay?
Just one, sorry. A test that came in recently that we were talking about earlier from the NFA, the black powder test, did we have time to, or did we conduct a similar test or check their results at all?
No, we haven't had time to do that.
Okay.
We just received it last week.
Fair enough. That's all, thank you.
Thank you. Having heard no further questions, I would again like to thank staff for being here, for your willingness to entertain our questions, and for your presentation, and for everyone, as Dr. Valeri mentioned, all who were involved in putting the package together. And again, I'll just repeat what I said earlier. This issue, more than many, has generated a tremendous amount of interest. And so to all who have offered opinions and shared their thoughts, I sincerely thank you for your input and for your engagement. It truly does inform the Commission. At this time, I will conclude the public hearing of the Consumer Product Safety Commission. Thank you all very much. I don't, I just have a folder.